appeal the Minister of Home Affairs and another, and Barbosa.
Mr. Drabb.
Very pleased, Your Lordship. In this case, I appear for Mr. Barbosa, together with my learned friend Peter Sanderson and my learned friend James Guthrie, Queen's Counsel, two respondents. Your Lordships will have seen that this is an appeal from the decision of the Court of Appeal, who reversed Mr. Justice Hellman. He had granted Mr. Barbosa a declaration that he belongs to Bermuda for the purposes of Section 11 of the Bermuda Constitution. The underlying, relatively short but important point or issue is the effect of Section 11.5 of the Constitution, which contains a list of categories of people who are, to use the language of the subsection, deemed to belong to Bermuda. It's common ground that Mr. Barbosa, who is currently a British overseas citizen by virtue of his birth in Bermuda, and who has lived in Bermuda for a very substantial part of his life, not within the categories in the list set out in Section 11.5. Both the first instance judge and the Court of Appeal thought that the result was anomalous and unfair to Mr. Barbosa. The respondent accepts that it is, expressly in his printed case. The Court of Appeal thought that the fact that he was not within a category contained in Section 11.5 was decisive. We dispute this conclusion. We say that the result cannot be reconciled with the approach of all members of the House of Lords in Banco No. 2, which was concerning the status of Chargosians as belongers. I should say at once that Mr. Barbosa, who is in court, is not the only one affected by the anomaly. Our best estimate that some 300 people are in roughly the same circumstances, at least potentially the beneficiaries of a ruling on the effect of Section 11. We propose, in essence, to proceed in essence in the manner and order we've set out in our statement of case, which consists of firstly looking at the Constitution, secondly establishing Mr. Barbosa's status as a British overseas citizen. That's a very limited number of provisions. We'll go to them if the court wants to see them, but they're very short. Thirdly, to look at the main authorities we rely on to establish a proposition that he is a belonger by virtues of his status as a British overseas citizen who acquired that citizenship by birth in Bermuda. Those authorities are Banco No. 2 and an authority I will tend to call Pomachowski, although that is 4 cases were heard together, and the actual case which raises the point and contains the dicta I rely on from Lord Mance is Halligan.
So is the nub of your argument that the definition in Section 11.5 is not an exhaustive definition and there remains a common law category of belongers?
Yes, there is a common law category of belongers, see Banco. 11.5 is, on its ordinary language, a deeming provision. It puts beyond doubt the proposition that all those who are in the list are belongers and who have the right contained in Section 11.1.
So it's a deeming provision designed to put beyond doubt categories that might otherwise have been in doubt?
Well, I don't think I need to say that. I'll come to exactly how to deal with 11.5 right. when we looked at the authorities. But the short point I make at this early stage is that the language of 11.5 is not designed, it does not have the natural effect of excluding people from the category of belongers. The language is one of deeming, which brings people in. Now, it may be that they're all in already. I don't mind that. We'll look at the approach the court should be taking to the construction of constitutions when we get there.
I'm sorry.
Well, I was just going to say, before we get there, you might want to be forewarned
Right.
that diligent members of the panel, or a diligent member of the panel, has discovered another provision which uses the same formulation of deeming. Perhaps I should let Lord Sales
yes.
speak, please.
So section 102 that's in the clip I think you've been provided with is the interpretation provision.
Oh, right, okay.
And section 102.3, page 75 at the bottom, says, for the purposes of this constitution, a person shall be deemed to possess Bermudian status. And then you see A and B. Now, at the moment, doing the best I've been able to understand this, those are exhaustive categories. But please help us if they're not. At all events, when you come on to section 11.5, if you could also assist us with what you say about the use of the same formula in section 102, that would be helpful.
Can I put down this marker? I mean, I certainly will do my best to do that. But can I put down this marker straight away? My submission will be, when we get there, that it doesn't matter what the draftsman of the Constitution actually thought at the time of drafting. The constitutional principles that we have to apply are that Section 11 as a whole should not be construed so in a way which cuts down the rights granted in Chapter 1 of the Constitution, unless the language inevitably produces that result, unless you can't get to my result as a matter of interpretation. But going beyond interpretation to simple desire or wishes that it said that, then you're in the territory which Lord Hoffman said in Matadine is not appropriate. But if what you're doing is applying an appropriate method of interpretation so as to produce a result which respects the rights in Chapter 1, then that is what you should do. I will have further thoughts about the use of the word deemed in 102.3. But I repeat, my submission on the use of the word deemed is that in its the natural meaning of deemed is to bring things in and not to exclude things. When we come to 11, what the attorney has to find, what the respondents have to find, is some provision which excludes people who have the common law status of belongers from the very right in 11.1, which you would normally expect to see mirroring.
But if the word deem it bears the meaning means,
yes,
then it would do. But that's the reason why I drew your attention to section 102.3, yes, where yes, the word deems does seem to bear that meaning, but we want your assistance with that.
It may do, but the principle of I'm not saying whether it does or not in section 102, because frankly I haven't thought about it, but I will think about it. But it's not an immutable meaning. You can perfectly sensibly imagine section 11, which is what we are concerned with, being drafted by a draftsman who didn't know there was a common law category. Just imagine that is the position. Common law has obviously been the same forever, but it may be declared with particular clarity at the moment of Banco. Then you have to make a constitution, which is a living instrument, work in a situation where people who have the common law right are excluded if you give a meaning to deemed, which is not in with respect, its natural meaning. Its natural meaning is that you're brought into a category which you might, or at least might not otherwise be in. So beyond doubt.
Would it not matter whether it was appreciated at the time of the Constitution that there was a common law right?
Well, no, my submission, it wouldn't matter. I mean, unless you get into the Matadine territory of it simply not being possible to get to my result by a process of interpretation, then you construe section 11 in accordance with the language actually used and the underlying intent behind section 11, so as to protect fulfil the rights that are established in Chapter 1 of the Constitution. Now, obviously, sometimes the language will be intractable, sometimes it will be quite clear that the draftsmen, or sorry, that the makers of the Constitution, probably more appropriate than draftsmen for this debate, didn't intend certain categories to come in at all. But if what they had done, jumping massively ahead in the argument, but if it simply hasn't been addressed and is perfectly possible as on an ordinary process of construction to achieve the result we ask for by interpreting the words of Section 11, but in accordance with the common law and international law norms, then that's where we get to.
And how far does that argument extend? Because the other provisions which have been copied for you include important rights that people with Bermudian status have to be members of the Assembly, members of the Senate, and indeed to be able to vote. So Section 29 and 30 deal with qualification for membership of the Senate and House of Assembly, and essentially you have to have Bermudian status. And Section 55 deals with qualifications and disqualifications of electors, and I think under Section 55(1 you have to have Bermudian status to be an elector. But are you saying that, well, you'd have all these rights if you're a belonger as well, and therefore all these provisions...
I haven't addressed that, and it's not a necessary part of my argument. I will give it, now you've asked me it.
But why not? Wouldn't, if you're right about there being a common law rights associated with being a belonger, would they extend to these sorts of rights?
Well, that's not the... I mean, I'm going to duck that for now. That's not the issue raised directly by this case. Just looking at Section 55. I mean, Mr. Sanderson is saying, which is obviously right, that our case is that the common law right established by Banku and Hartigan or whatever is directly mirrored in Section 11, so that unless you adopt my construction, you get a disconnect between the common law position and the protection afforded by the Constitution. That's the fundamental point, and we say there's no reason to construe the Constitution in that way. What impact that has on people with or without Bermudian status, where there isn't the common law or international law underpinning, is a different issue. It's because...
Well, that's why I was asking you how far your argument extends.
Well, it certainly doesn't extend necessarily to impacting on these provisions, because the critical part of our argument is that you look at the common law, which reflects an international law norm. The common law provides for a right of entry and abode within the territory of which you are a citizen. Now, I know there's a quirk about citizenship here, but I mean, which we'll need to tease out. But it certainly, I mean, we say that that Banku establishes that the same line of reasoning applies to belongers. So it's not just citizens, it is belongers. And so that outside the machinery of Section 11 is a common law and international law norm. That's the crucial thing. So when you come to construe the relationship between 11.2d, which is the one that potentially cuts down the right granted by 11.1, you should do so on the basis that the Constitution must operate against the actual background that exists of international law and the common law, and not cut it down if the result is to produce the disconnect which my learned friend's case does produce.
Do you say that reading Section 11 of the Constitution and the way in which the Court of Appeal read it leads to a violation of international law?
Yes. Potential violation. I mean,
in due course,
you can get quite difficult issues.
Define what rule is broken.
Yes.
In due course.
Well, I mean, I can do no more than show your lordship the passages in Banco and Hartigan, if that's the Portuguese, which talk about it. And it's, your Lordship will have seen that part of the material which is relied on is the very short statement by the Luxembourg court in Van Doyen about
But that addresses, as I recall, citizenship and nationality. We're dealing with a rather different concept here. And it's on that I'd be grateful for some assistance in due course.
The answer to that has to be in Banco, but...
Yes.
May I just be clear that you say the common law right extends at least as far as the rights identified in 11.1?
Yes.
Right.
They're coterminous. I mean,
So they're coterminous.
what Banco establishes in terms is that belongers have the right to remain in the territory of the unit of British overseas territories, as it would now be, to which they belong. So, a citizen of British overseas territories, that's a very wide unit, but Banco establishes in terms that you apply the international law norm that I'm being asked about to that situation by looking at the unit to which you belong. If you don't do that, Mr. Barbosa is a citizen, a British overseas citizen, but there is no territory to which he has a right of entry. The citizenship carries no rights of entry. And that's the disconnect, which is a fundamental part of the case.
So you say in his capacity as a British overseas territory citizen, he has no right to enter and remain in Bermuda?
Yes.
Yeah.
And indeed, part of my learner friend's case is that this doesn't matter because he's been granted indefinite leave to remain, which is true. But that in itself highlights the problem. He needs indefinite leave to remain on my learner friend's case. He could have simply limited leave to remain, perfectly consistently with 11.2. We say that's all inconsistent with the structure of rights established by Banco and Hartigan.
Obviously, we're just in the preliminaries at the moment. But
unusually.
as you'll gather, we have been thinking about this.
I do gather.
And one matter that would be helpful if you could explain at some point is what the relationship is between BOT citizenship and British citizenship. I mean, for example, whether your client has British citizenship. And when we're talking about the common law, you will need to make good your proposition that Banco does really establish a common law category of belongers. And speaking for myself, I'd like to try to understand how this makes sense historically. If we think about the British Empire in the reign of Queen Victoria, or of the colonies under George III, one might have thought that if you were one of Her Majesty's subjects living in India in the 19th century or in Virginia in the 18th century, you had, by virtue of being one of the subjects of George III or Victoria, you had a right to enter and remain in all of Her Majesty's territories, which flowed from the relationship of subject and monarch. Rather than thinking in terms of your having rights by virtue of rights specific to Virginia or Bermuda or India, as the case might be, depending on which particular part of the empire or which particular colony you belong to.
Yes.
So when you come to deal with common law, it'd be useful for that to be covered.
Yes, my answer is that the approach of the members of the Lords was expressly articulated against that background. It's for that reason that Lord Mance talks about a right to enter the unit of territory of which you are a citizen. And no doubt your Lordship is correct confronted this in the cases about immigration rules, RVM Manier, about if you go back to the situation before the Commonwealth immigration legislation in the late 60s, the position that your Lordship is describing would be accurate. Since then, it's not been possible to describe it in quite those simple ways, and so that the dicta of Lord Diplock in Bagwan about the right to come and go as you desire, as you list, I think is the word that's used, becomes impossible to apply to the whole unit of which you are a citizen. But the dicta have taken that on board, and Chagos expressly, the banker expressly applies the thinking to look at a right to enter the unit of territory by virtue of which you hold the relevant citizenship. Now, I'm not going to get much better than that. I mean, that is the submission.
And when we come to the case,
Yeah.
speaking for myself, I'd be particularly interested to see what's said by the majority.
Yeah.
You appreciate the judgments you're relying on are those of judges who dissented in the result.
Yes, I understand that. I certainly will do that. And I mean, we've been talking about common law rights. I don't need, for these purposes, to go any further than Lord Hoffman, who articulated the basic approach of the majority. But all I need is something about my client's status acquired by birth in Bermuda, which forces a particular approach to the construction of Section 11. The easiest way of describing it is a common law right, because that rides alongside the international law norm that I rely on. But even if you simply say his rights are not to be taken away except by express and unambiguous words, that's good enough for me. And that is the approach of the majority.
Just, if I may, to pursue the point raised by my Lord, might it not be said that in the common law, the critical relationship was not a relationship of citizenship? I'm not aware that the common law historically talked about citizenship, but of being subject of the Crown. So, and if that's right, doesn't that create some difficulties for you? Because with the, if you like, the breakup of the empire, one's moved away from a concept of being the subject of the Crown and being able to go anywhere where the Crown has dominion, to what is a new concept of citizenship or nationality or concepts of belonging to particular units.
That issue is expressly addressed by Lord Bingham. I mean, I know part of the minority for these purposes in Banco, but I mean, he puts the relationship between the sovereign and the citizen together to end up with a proposition that what the sovereign can't do compatibly with that relationship is expel the individual subject, this will be the language of which we're using to describe this, from the territory by virtue of which he possessed, he owed the duty of allegiance, in respect of which the Crown owes the duty of protection. The two go hand in hand, and they reinforce the proposition that the one thing that can't happen is that you have no territory to which you can go by virtue of the relationship between yourself and the Crown. I mean, Lord Bingham says that in terms. I think it's Bingham, I'm pretty sure it is. Yeah. But he is part of the minority, I understand that. But.
So I might just ask one other question. As I understand it, the concern which led to these proceedings included a restriction on Mr. Barbosa's employment opportunities,
yes.
Their ability, he and his wife's ability to purchase property. Do you say the common law right extends that far?
There's Court of Appeal authority in Bermuda which suggests the answer to that is no, but the common law right, the restrictions on employment and business opportunities which your Lordship is referring to are all, as a matter of domestic law in Bermuda, predicated on the basis that they apply to people who don't belong, who are not, do not have the appropriate status. So all we're concerned with in this litigation is to establish that Mr. Barbosa is a belonger. That would seem I mean, the problems that your lordship is describing can be seen as basically work permit issues. I mean, it's the right to work and so on. Now, I certainly do say it would be an odd situation, to put it at its lowest, that you required authorization to work if you were, let's go to a unitary state, a citizen of a unitary state who had the unambiguous right to reside there. That's not the immediate issue here. The immediate issue is whether he has, by some mechanism other than 11.5, the right that is granted by 11.1. Because the moment you get there, then you have to construe the Constitution so as to produce a workable result in that way.
Thank you.
Well, Mr.
I may have slightly ducked my question, but that's what I'm doing my best.
Well, you've dealt very patiently with our questions. As you can see, the case has captured our interest to an unusual degree.
Well,
but we will now keep quiet and let you develop your
I'm glad to say I have done some thinking about it, but not necessarily the right thinking, but we'll find that out. Right. Now, hang on, what have I said? So, yes, I propose to the argument is look at the Constitution, established by Mr. Barbosa's status as a British overseas citizen. I limit a number of provisions and nothing particularly turns on them, on the language of them. Then look at Banco 2 and Halligan. Then look at the authorities which are relevant to the construction of constitutions such as the present, which has informed some of the responses I have given to your lordships about how much it matters what was actually in the mind of the draftsman of Section 11, or what the approach is that this court should take to the construction of Section 11, given its actual wording. And then to look at other material that supports our proposition, in particular very shortly ex parte Sims, and then dealing with the meaning of the word deemed in accordance with our printed case. But I'm not going to say anything very elaborate about that. I've said it already. So can I then go to the Constitution, which your lordships will find in Volume 1 of the Authorities Bundles, Tab 1. It starts at page 134, and we're looking at the Schedule 2 to the Bermuda Constitution Order, and we are looking at the Constitution. If you just look, just to get at the list of contents, page 134.
Can I ask, was there a white paper that lay behind the introduction?
I haven't seen one. We haven't seen any travel, have we? For the Constitution.
There's a constitutional conference.
There was a conference.
Might that help us with interpretation of it?
I haven't produced anything, and I'm not relying on anything. I don't think the attorney is either. In any event, if we look at Schedule 2, at the content section, page 134, we're concerned entirely with Chapter 1. Article 1, or Section 1, deals with the fundamental rights and freedoms of the individual, and your lordships will see and already gather that Section 11 is one of those rights and freedoms, deals with protection of freedom of movement. And the relationship between Section 1 and Section 11 is discussed in a case which we'll need to come to called Fisher, where Lord Wilberforce discussed the principles to be applied in construing a constitution of this sort. Because your lordship saying...
Can I ask you, this is 1968, so the context in which this is introduced would be one where the relevant status under UK legislation would be citizen of the United Kingdom and colonies. Is that right?
Yes, I'm being told the answer to that is yes.
Yes.
I think we can see that from the note to 5B,
Oh, thank you very much, Mr. Guthrie.
section 11.5B.
Right. Yes, Mr. Drabble.
So, going on then to the body of the Constitution, Section 1, EB 139, I won't read it. Your Lordships will see that it states that whereas every person in Bermuda is entitled to the fundamental rights of freedom as the individual, and then sets them out, and then states immediately below C, so the provisions of this chapter shall have effect for the purpose of affording protection to the aforesaid rights and freedoms, subject to such limitations of that protection as are contained in those provisions, being limitations designed to ensure that the enjoyment of the said rights and freedoms by an individual does not prejudice the rights and freedoms of others in the public interest. As I say, Lord Wilberforce in Fisher says that Section 11, to which we now come, is one of the rights and freedoms described in Article 1. So if I am right about the effect of Banku, construing Section 11 on the basis that its purpose is to give effect to the rights described in Section 1. So come to Fisher in due course. And then if we go on straight to Section 11, EB 146, (11.1) provides that except with his consent, no person shall be hindered in the enjoyment of his freedom of movement, that is to say, the right to move freely throughout Bermuda, the right to reside in any part thereof, the right to enter Bermuda, and immunity from expulsion therefrom. Now, as I've already said, it's an important part of my case that that Section 11.1 right is the right described in the international law, in the statements about international law, that in the cases that we'll come to look at, and is coterminous with the common law right described in Banku.
But sorry, 11.1 is talking about any person.
Yes, I know, because that's cut down by the next provision we now need to come to, which is a crucial part of the argument, which is 11.2d, which is the top of page 147, sorry, I'm just trying to find it. So read 11.2 and then go on to D. 11.2, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section to the extent that the law in question makes provision, then D, for the imposition of restrictions on the movement or residence within Bermuda of any person who does not belong to Bermuda, or the exclusion or expulsion therefrom of any such person. So the way in which the right works is you're given the right by one unless you fall within D on the basis you do not belong to Bermuda. So the crucial phrase, actually a negative phrase, is Mr. Barbosa someone who does not belong to Bermuda. It doesn't make much difference, I think, but that's what we're concerned with. And then we go on to 11.5. For the purposes of this section, a person should be deemed to belong to Bermuda if that person, A, possesses Bermudian status, and then there's another list which includes people who are naturalised, wife of a person, the foregoing paragraphs of this subsection, not living apart from the person, or is under the age of 18 years and is a child, etc. Lordships can read it in this subsection.
Can I just ask on that, would it be possible for Mr. Barbosa to be naturalised by the government?
No, because of a quirk in the chronology of his history. There isn't a way out of it on the present basis.
Just that directly.
Yeah.
So,
if you don't mind Mr. Saunders saying.
So Mr. Barbosa is born as initially a citizen of the UK and colonies, and then in 1981, the British Nationality Act made a distinction between British and BOT citizens. So he has BOT citizenship today by birth. If you have a citizenship already by whatever means, you can't get it a second time. You can't naturalise to become something you already are. Theoretically, it's possible, I guess, for him to go through a process of renunciation and then applying to naturalise if he can satisfy the governor that he would meet the naturalisation conditions. But that would be a complicated process which may or may not be possible, and certainly is not his position today. Because in order to naturalise, you'd need to meet certain other conditions, and you need to obtain the cooperation of the governor to go through that novel process. But as of today, he's a born BOT citizen, not a naturalised one.
Right. So the certificate of naturalisation, where it's issued, is to make someone a citizen of an overseas territory. Is that right?
By way of naturalisation, which is contained, I think, in section... the bundle has a reference to I think the bundle at tab 3 has got some excerpts of the British Nationality Act, 1981, but not, no, it doesn't, I'm not sure it includes naturalisation sections, which I think is section 18 of that Act, of the 1981 Act. And Schedule 1 deals with how somebody can naturalise, but clearly you can't naturalise if you already have it. You can't become a double BOT citizen.
Right. And while you're assisting us on the facts, can I just ask, what is the nationality of Mr. Barbosa's parents?
Portuguese.
And is he a Portuguese national as well, then?
He would also possess a Portuguese citizenship, yes.
All right. Thank you very much.
The answer which I was slow to come to is that the naturalisation is not, it's a trap easy to fall into. It's not naturalisation as a Bermudian, it's naturalisation as a British overseas citizen granted by the governor in Bermuda, I think. Yeah, by the governor. So that's the Bermudian link. The person who grants you the certificate of naturalisation.
Yes. So has 11.5b been amended so as to refer to the more modern legislation? Or are we looking here at the original version but not the current version?
Yes, it's text, as I understand the position, the text is the current text.
Yes.
But it's subject to interpretation provisions described in the note.
And the British Nationality Act itself.
Yeah.
The British Nationality Act itself, I believe, is section 53. It's not, I don't think that section is before you, I'll just check. The British Nationality Act itself has interpretation provisions which set out how other acts and instruments are to be read.
Yes.
And so the interpretation provisions of the 1981 Act say that in any other acts or instruments of which the Bermuda Constitution is an instrument, then references to nationality or citizenship should be...
In fact, I think that probably follows from the Interpretation Act of 1978 anyway.
Yeah.
Yes, thank you.
So we're fine. We get to the same point.
Yeah, thanks.
Mr. Drabble, is the reference to Bermudian status in section 11.5a, a reference to what is now the Bermuda Immigration and Protection Act 1956.
Yes, yes.
To what did it refer originally?
The 56 Act predates the order, so I think the reference is always
quite right. It predates that, so it refers to the 56A. Thank you.
I mean, it seems to me unlikely that there would not have been some discussion of who was to have various rights in Bermuda in the constitutional convention that you've told us about.
Yeah, I can certainly have another think about that, but we can't take
Perhaps
that
we
in
could be assisted at least by being provided with whatever
a
was
reference. Yeah.
produced as a result of that convention. Thank you.
Yeah.
Yes, one would think at least the Attorney General would have access to that
Exactly.
record.
Yes. I mean, can I just say in my own defence at the
Yeah.
moment, there is no case from the attorney
Yes.
that Mr. Barbosa does not possess whatever you want, whatever right you want, whatever language you want to describe, the effect of banker. And it's not saying he's not within the ratio of banker or anything of that sort. So I'm not facing a positive case that he doesn't have the rights. The case against me is that section 11.2, well, the case against me actually is that section 11.5 is a definition section. Yeah. It's as simple as that. Yeah. It just is a definition section. And we say that doesn't work with the word deemed once you realise there's something outside the machinery of section 11 which might be constitutive of right. So that's where we actually get.
I appreciate it boils down to a short point.
No.
The surrounding context is quite...
Of course, of course. Yeah. So if we go on through, that's section 11. The actual issue in the case is the relationship between 11.5 and 11.2d, because unless you construe the words "who does not belong to Bermuda" in 11.2d as requiring someone to be within the 11.5 list in order to belong to Bermuda, then my client does belong to Bermuda, see Banco, and he possesses, as one would expect, the right created by 11.1. So it's the combined effect that matters. If we go on through the Constitution, there are various other provisions, in particular in section 12, that refer to people belonging to Bermuda for the purposes of section 11.
You say in particular, I
don't think there are any others, actually.
No,
Yeah, that's my caution of whether I've been careful enough last night to make sure that's the case.
No, thank you.
But if one looks at section 12, section 12 provides subsection 1, subject to the provisions of 4, 5 and 8 of this section, no law shall make any provision which is discriminatory either of itself or of its effect. And then discriminatory is defined in subsection 3, and then subsection 4 states subsection 1 of this section shall not apply to any law, so far as that law makes provision. And then A is dealing with revenue, with taxing. B, with respect to the entry into or exclusion from or the employment engaged in the business, profession, movement or residence within persons who do not belong to Bermuda for the purposes of section 2 of the Constitution. So you can have a regime which regulates employment rights.
I think that should be section 11, isn't it?
Sorry,
it's been printed incorrectly.
Yeah, I don't which I said.
Roman 2, I think.
Yeah, it appears as section 11 in subsection 5 later.
And then Lord Sale's obviously seen and familiar with 5, but the same phrase occurs within 5. Nothing contained in any law should be held to be inconsistent with or in contravention of subsection 1 of this section, to the extent that it requires a person to possess Bermudian status or belong to Bermuda for the purpose of section 11 of this Constitution, or to possess any other qualification in order to be eligible for appointment to public office, which is essentially what this is about. Now, I don't think it matters to the argument, but I had originally not realised that there were 2 matters which on the basis of which you could discriminate lawfully in relation to subsection 5. One is Bermudian status, and the second was belonging to Bermuda. So the 2 are contrasted, or the 2 are not coterminous. But as I say, I don't think that matters. Now, those are the provisions of the Constitution that are directly in play. Mr. Barbosa's British overseas citizenship established in the following way. If your lordships will pick up our case at EB 106, the paragraph actually starts at EB 105, paragraph 3, and we've given your lordship the references to the various steps that were necessary to come to his current status. If your lordships will just look at the 1948 Act at tab 2, EB 155, particular section 4, which is EB 158. Section 4 provides, subject to the provisions of this section, every person born within the United Kingdom and colonies after the commencement of this Act shall be a citizen of the United Kingdom and colonies by birth, provided the person shall not, and then the lordship can read the rest. Simple birth within the United Kingdom and colonies. As that provision, of course, he was born in Bermuda.
Is this the first statute that introduces the concept of a citizen of the United Kingdom and colonies? It goes back to what I was raising with you before, that I'm not aware that citizenship as such is actually a concept of the common law.
No, it might have been introduced in the 1914 Act. Without checking, I wouldn't know.
Yeah, the point of your lordship's question, the target is when the concept of citizenship began to be part of this.
And associated with that, is it a statutory concept rather than a concept of the common law?
Yes.
I think the answer is it comes in 1914 as a statutory concept.
The alien
But one would have to check that.
And the question would be whether that was simply British citizenship or whether it was the concept of citizenship of the United Kingdom and colonies, which I suspect came from the first time in 48.
Before the 48 Act.
But I'm not sure about that.
Yeah. So, next on the list, 1st of January 1983, he became a British dependent territory citizen by virtue of the operation of Section 23. That's 165. B165. Your lordships will see Section 23. A person shall at commencement become a British dependent territory citizen if, A, immediately before commencement he was a citizen of the United Kingdom and colonies, held that citizenship by his birth, naturalisation or registration in a dependent territory. categories. Barbosa satisfied that provision, again, by virtue of his birth in Bermuda. And then finally, it's a renaming exercise at EB169.
It's interesting. I've got the 1914 Act in front of me, and it dealt in Part 1 with natural-born British subjects,
Yes.
who were, the following persons shall be deemed to be natural-born British subjects, and they begin with any person born within His Majesty's dominions and allegiance, and then deals with people born outside His Majesty's dominions whose father was, at the time of birth, a British, or of that person's birth, a British subject. And then Part 2 deals with naturalisation. So it's allegiance to His Majesty and birth within His Majesty's dominions that's critical.
Yeah, it's okay. Got some thoughts about that.
Use of word. Yes, and use of word deemed,
Yeah,
obviously.
I
is,
mean, it rather sounds from what my Lord says as though the formula used there was intended to be exhaustive.
well, the head note is definition of natural-born British subject, and then says the following person shall be deemed to be natural-born British subjects. Yeah. But we're taking you out of what you've prepared, Mr. Traveller.
I don't mind. Within reason. No. So I think that's the chain, which leads to the position that my client is a British overseas citizen. Now going to come to the cases which I say demonstrate that by virtue of that status, citizenship or being a subject, but by virtue of that status, he must have the right to belong to some unit of territory. In the world in which we now are, that means looking at the individual dependent territory to which you belong.
And I'm so sorry, Mr. Drabble, I fell slightly behind with the 2002 Act. Am I right in thinking that Section 3 of the 2002 Act conferred British citizenship on persons who were British Overseas Territories citizens, including Mr. Barbosa? So is he a British citizen as well?
He is a British citizen as well, is it? By virtue of Section 3?
He has the right to come to the United Kingdom as a British citizen?
Yes.
So he's not left homeless in the world?
No, it's not my case he's stateless or anything of that sort, but he does have a particular citizenship.
Yes, thank you.
Which would, on the face of it, carry with it right to enter the territory by virtue of which he acquired that citizenship.
Yes, thank you.
So if we go to Banco, number 2, spend a very long time describing the background of Banco, but I'm not going to do that. I'm capable of doing that. But if we can go straight to the passages that matter. Your Lordships go to the passage in the judgment of Lord Hoffman at paragraphs 42 through to 45.
Sorry, which tab?
It's EB 537, and it's tab 20. Yeah.
Thank you.
It's just tab 20. So within that, if we can go to 537. Lord Hoffman says, is dealing with an argument advanced by Sir Sidney Kentridge on behalf of Mr. Banco and giving his reasons for rejecting it. He says, Sir Sidney's proposition that the Crown does not have power to remove an islander's right of abode in the territory is, in my opinion, also too extreme. He advanced two reasons. The first was that a right of abode was a fundamental constitutional right. He cited the 29th chapter of Magna Carta, no freeman shall be taken or imprisoned or exiled or otherwise destroyed by the lawful judgment of his peers or by the law of the land. So that's Sir Sidney, going back to the shape of the discussion we've just been having, Sir Sidney asserting that the position that prevailed under Magna Carta, where the relationship would be of Crown and subject, was carried over into the position in relation to the Chalgassians, where they have become citizens of British overseas citizens, essentially, by reference to their status in relation to the Chagos Islands. Now, we'll see the precise way in which Lord Hoffman deals with Sir Sidney's argument in the next two paragraphs, but he's not saying the starting point is wrong. He's accepting that the right of abode exists. In essence, the split between the majority and the minority in Banco is a split between them about the legitimacy of the mechanism by which it was removed, as we'll see in a moment, Lord Hoffman. So he says, 43, very foot of EB 537, but by the law of the land are in this context the significant words, like Blackstone, Commentary on the Laws of England, 15th edition, but no power on earth, except the authority of Parliament, can send any subject of England out of the land against his will, no, not even a criminal. That remains the law of England today. So stop there. We've moved into a world in which you're dealing with citizenship, if you're looking at the law of England.
Well, the quotation from Blackstone is any subject of England, and the way Lord Hoffman in the next sentence puts it is at common law any subject of the Crown.
No, but with respect, if we read the first three sentences, that remains the law of England, of 44, the law of England today. The Crown has no authority to transport anyone beyond the seas except by statutory authority. At common law, any subject of the Crown, I agree that's expressed in terms of subject, has the right, but he's certainly, sorry, I'm glossing it as I read it, which is a mistake. Any subject of the Crown has the right to enter and remain in the United Kingdom whenever and for as long as he pleases. See the Crown against Bagwan. The Crown cannot remove this right by an exercise of the prerogative. This is because since the 17th century, the prerogative has not empowered the Crown to change the English common law or statute law. In a ceded colony, however, the Crown has plenary legislative authority. It cannot make or unmake the law of the land. What these provisions show is that the right of abode is a creature of the law. The law gives it and takes it away. In this context, I do not think that it assists the argument to call it a constitutional right. The Constitution of Biot denies the existence of such a right. I quite accept that the right of abode, the right not to be expelled from one's country or one's home, or even one's home, is an important right. General or ambiguous words in legislation will not readily be construed as intended to remove such a right. See Sims. But there's no such question arises in this case. The language of Section 9 of the Constitution Order could hardly be clearer. The importance of the right to the individual is also something which must be taken into account by the Crown in exercising. The importance of the right to the individual is also something that must be taken into account by the Crown in exercising its legislative powers, a point to which I shall in due course return. But there seems to be no basis for saying that the right of abode is in its nature so fundamental that the legislative powers of the Crown cannot touch it. As I say, that's the divide between the majority and the minority, the majority holding. But the right of abode can be removed by legislation, and in the context of the Chagos Islands, that meant by Article 9 of the relevant order in council, and the minority saying that wasn't an available approach. But no one is saying that the relationship between citizen and the state in a modern world produces a different answer to the existence of the right of abode from the traditional subject-crown relationship that your lordships were putting to me about the 1914 Act. None of the members of the court proceed on that basis.
So, I mean, so far as Lord Hoffman goes, so far, it rather looks as though, at common law, by virtue of being a subject of a crown, you would have a right to enter and remain in any of the crown's dominions, which would include Biot and indeed Bermuda. Yes. I don't think he doesn't deal with the subsequent developments that are in the back of all our minds, which effectively restrict immigration rights within the larger territory. In the UK, the legislation of the late 1960s, Commonwealth Immigration Act, and so on. So he doesn't deal with that development. Lord Mance does deal with that development. Or at least uses words which accommodate that development. We'll come to them in due course. Now, my case, just to make it clear, is that you start out with a subject-crown relationship which is across the whole of the empire. I'm perfectly happy with that. But then in the modern world, it doesn't work like that. You have to ascertain the unit of territory by virtue of which you are, to use the modern language, a citizen, a modern concept. You are a citizen, and you have a right of abode in the territory of which you are a citizen.
But isn't that concept given by the constitution of each of the overseas territories taken one by one?
Well, that's in a sense what we're talking about.
Well, I agree.
If by unambiguous language, Section 11 removes the right of abode from someone who would otherwise have the right, then I would agree with your lordship, but it doesn't. Or at least I say it doesn't. That's the debate between us. There might be different international law arguments if you did that, because you would end up with a citizenship which carried with it no territorial rights, if I can use that rather bad phrase.
What was it common ground in Banco that the islanders had a right of abode before the relevant legislation was in?
No. No, it wasn't. I mean, it wasn't common. I mean, the government's answer, one of the government's answers to Sir Sidney's argument was that there was no right of abode. And I don't know whether your lordship's picked up in the first instance judgment in the present case, Mr. Justice Hellman deals with what Lord Wilberforce says in Fisher, where he talks about Section 11.5 being a definition, and says that was all overturned, and no one was, it was put to Lord Wilberforce that there was no right of abode, but that was wrong, as established by Banco to be wrong.
Just as a matter of timing, I think I'm right in thinking that the 1968 Constitution did not remove any rights of Mr. Barbosa because he hadn't been born then.
That's right.
Yeah. Well, I say we need to come back to 11, the relationship between 11.1 and 11.2, which is what your lordship's question is going to when we've looked at the authorities. No, I don't actually need anything more. I mean, I don't think I could usefully go to anything more out of Lord Hoffman. We then go on to one of the minorities, Lord Bingham. And we pick it up at page 491, paragraph 70, EB 544. House was referred to no, paragraph 17, the House was referred to no instance in which the royal prerogative has been exercised to exile an indigenous population from its homeland. Authority negates the existence of such a power. Sir William Holdsworth states, the Crown has never had a prerogative power to prevent its subjects from entering the kingdom or to expel them from it. Lord Justice Laws, in paragraph 39 of his Banco No. 1 judgment, which the Secretary of State accepted, cited further authority. For my part, I would certainly accept that a British subject enjoys a constitutional right to reside in or return to that part of the Queen's dominions of which he is a citizen. Sir William Blackstone says in commentaries on the laws of England, but no power on earth except the authority of Parliament can send any subject of England out of the land against his will, no, not even a criminal. Compare Chitty, Plender International Migration Law, and a quote from Plender.
Have I understood you correctly that you say the first sentence from Lord Justice Laws there is too narrow? Because I think in the exchanges earlier this morning, you were accepting that if one goes back, say, to the 19th century, it's a right to go into any part of the Queen's dominions. He doesn't need to be a citizen of it. That concept didn't exist.
That concept didn't exist, no.
Right. So I just want to be clear what you're saying. You're saying that first sentence is too narrow.
I don't think I need to say anything about it, except that when we get on into the later into the rest of the judgments, both in here and in Lord Mance's judgment in Pomachewski, we can see the way in which it is actually applied in modern concepts of citizenship.
That sentence is the first time we've seen a link being made between the common law concept of being a subject and the statutory concept of being a citizen.
Yes.
And, we're waiting to see authority for that link. Because we've seen in Blackstone the common law in relation to subjects, which Lord Hoffman summarised. But Lord Justice Laws, I think, as I say, is the first person who's tying it into the modern world of citizenship.
The line of cases on which I rely treats the older statements in Magna Carta and the statements that underlie Lord Diplock's approach in Bagwern, which obviously relate to a subject-crown relationship, as informing the way in which you approach the contemporary position. Now, how fully reasoned out we're going to find that, I don't know, but that is the present position. Now, I think I got to, sorry.
To Plender, I think.
The quote from Richard Plender, International Migration Law. The principle that every state must admit its own nationals to its territory is accepted so widely that the existence of the rule of law is virtually beyond dispute. Now, pausing there, to put at that point in terms of nationals, and of course the Chargassians were not nationals of the Chagos Islands, they were nationals of the wider unit. But we'll see how that works. Is accepted so widely that the existence of the rule of law is virtually beyond dispute, and cites authority of the European Court of Justice in Van Duyn, in which the court held that as a principle of international law, that its state is precluded from refusing its own nationals the right of entry or residence. That's the statement of international law that feeds on into the later dicta in this case and in Pomachewski. Dr. Plender further observes international migration law, a significant number of modern national constitutions characterize the right to enter one's own country as a fundamental or human right, and a long list is given. And I should cite this passage. Without exception, the remaining dependencies of the United Kingdom impose systems of immigration control applicable to British citizens coming from the United Kingdom and to those from other dependencies. In two very exceptional cases, immigration control is applied to all persons whatever. Elsewhere, a distinction is drawn between those who belong to the territory and are accordingly immune from immigration control and those who do not belong. In several instances, the statute uses the very word belonger, as a person has the right to land in Hong Kong if he's a Hong Kong belonger. Dr. Plender's two very exceptional cases are the British Antarctic Territory and Biot. The English Antarctic Territory has no belongers, Biot has. So we've morphed in the passage from the opening words to treating those statements of principles via what Dr. Plender says, admittedly, to an approach in the modern world where each dependency will have its system of immigration control, and the right becomes a right to enter the unit by virtue of which you possess
But I mean,
citizenship.
isn't an issue for us that you're moving from statements, Mr. Plender's statement about admitting its own nationals, to a situation where, in relation to British overseas territories, one doesn't have the concept of nationals as such.
Well,
you have the concept, in the Bermudan case, of belonger for certain purposes, but also the concept of Bermudian status. Now, if the concept of Bermudian status is what actually maps on to the notion of nationality, then there's no difficulty about what happens in Bermuda, because persons with Bermudian status do have full rights of abode. The question for us is, isn't this right, is whether there's a wider concept going beyond status of belonger, which carries the same rights. And that's, if I may say so, Mr. Drubb, just so you understand why I raised with you the points about the rights that people had to be electors and so on, Section 55, and to be members of the Assembly. That's all framed in terms of you having Bermudian status, as one would expect if status is equivalent to nationality. One expects, if you're a national of a place, that you can exercise a right to vote, stand for Parliament, and so on.
Yes.
So doesn't that tend to indicate within the scheme of the Bermudian constitution that when one engages in the mapping exercise that we have to do, actually the relevant concept that nationality maps onto is Bermudian status? I mean, it's different, it depends on the overseas territory and what their particular constitutions say. Some do just talk about belongers, in which case that's, if you like, the only candidate to map on the notion of nationality.
Yeah. And if I may just add to that, it's also, as implicit in what my Lord's just said, that in these latter passages quoted from Dr. Plender, we're no longer in the world of a common law. What he's talking about is legislation, or modern national constitutions, and dependencies which impose systems of immigration control, and then he's describing how they draw a distinction between belongers and non-belongers, or equivalent expressions.
Well, but there's the whole passage is predicated on the proposition that if you belong, not particularly, belong matters because that's what we're considering in Section 11, it doesn't otherwise matter. If you have a right to enter and remain in the territory by virtue of your citizenship, in modern terms, granted as a result of your connection with that territory, then that must be given effect to. That's a reciprocal relationship which was described by Lord Bingham immediately over the page.
What I'm making is he's no longer, Richard Plender in these passages isn't speaking about, he's not telling us what the common law is. He's describing the constitutions or immigration control systems of British dependencies.
Well, that's certainly true at the foot of the page. But, I mean, he starts with the proposition which echoes in a modern context the very opening of Lord Justice Law's proposition, just below letter F.
One can perhaps say that there's a functional equivalence between the common law world of British subjects and their rights throughout the Queen's dominions and the modern world of immigration control systems which confer similar rights on people described as belongers. But that then doesn't help us when we come to Section 11, I wouldn't...
Well, but with respect, it does, because I can't be worse off than Lord Hoffman's approach in the passage to which I've already referred, it's 45. I mean, Lord Hoffman's approach doesn't depend on calling this my client's status in, loosely, I don't mean to reflect any constitutional status, my client's status as possessing a common law right. Indeed, Lord Hoffman deliberately disowns the need to label in that way. That's his point. He just says...
It was a constitutional right.
Well, he doesn't think you even need to label it like that. I mean, he is saying, I quite accept, and this is just below the letter C, quite accept that the right of abode, the right not to be expelled from one's country or even one's home, is an important right. Yeah. So stop there, and then he goes on to ex parte Sims.
Yeah.
Now, that's all I need to produce a situation where you apply that principle of construction to Section 11, because otherwise you will produce a world in which my client doesn't have a right of abode in the territory of which he is a citizen.
Yeah, I mean, that's a rather less technical argument. Well, you're not having to say there is a residual common law category of belongers. You're saying it's anomalous if somebody who was born in Bermuda and who's lived there all their life doesn't have the right to enter and remain there.
Yep.
And if that's the consequence of Section 11.5, then one would incline to construe Section 11, well, one would be inclined to construe Section 11.5 in a way that avoids that anomalous consequence.
Yes. Well, I'm trying to find out the way in which I've expressed it. My submission is that you get out of Banku, including the approach of the majority, looking at the relevant paragraphs of 45, something that's operating outside Section 11, which produces a particular approach to the interpretation of Section 11. Now, some members of the court in the minority described it as a constitutional right or a common law right. I don't need that, actually. I just need to say, well, hang on a sec, we've got a deeming provision. You've got the use of the word belonger. If you construe belonger as not giving you the Section 11.1 rights, and to allow you to be taken out of the Section 11.1 rights, then you are producing the anomalous situation that you're a citizen without a territory. Clear words in the Constitution could produce that effect, according to Lord Hoffman, and I no wish to not accept that. But you've still got something that's outside. You can't construe Section 11 as a completely self-contained code in which 11.5 is a definition section. The language doesn't say that, and there is something outside Section 11. So, as I'm sure I should do say somewhere in the case that even if we stop at paragraph 45 of Lord Hoffman, we win.
Well, provided that it's common ground, or you can demonstrate that a person who, unlike your client, had been born before the Constitution was enacted, had a right of abode by virtue of birth.
It's enough for my purposes to show that he has a status, I'm using again the word loosely, that brings into play the principles of interpretation that are articulated by Lord Hoffman in paragraph 45.
But Lord Hoffman's principle is articulated, as I understand it, on an assumption that the person has a right of abode at the point when legislation purports to take it away. And the question then is whether it does so with sufficient clarity. No. That's why I asked whether it was common ground in Bank, and you told me it wasn't, that the islanders had a right of abode before the relevant ordering council was made.
Lord Hoffman certainly proceeds on the basis, which is shared expressly in two powerful judgments from the minority, on the basis that your connection, i.e. Mr. Banco's connection with the Chagos Islands, was enough to bring into play the principle which he's described in paragraph 44 as the law of the land. Now, my learned friend's case against me doesn't dispute the existence of that right, or before he just said it's irrelevant because the wording of Section 11 is so clear that it's removed. But there's no attempt, as I understand it, to say the principles applied in Banco don't apply.
Just on the question of anomaly, I mean, there are lots of people born in the United Kingdom who've lived their whole lives here, but born to parents with a different nationality, who don't become nationals of the United Kingdom simply by virtue of those facts.
Yes, I know, but they won't be citizens. they won't possess a citizenship of the United Kingdom on that particular example.
But doesn't that take one back to what is the relevant analogy in the mapping exercise when one's thinking about nationality? Because most of the international statements are by reference to nationality. And if in our case the relevant analogy is Bermudian status, then...
What your Lordship is putting to me is that it's acceptable as a matter of international law that you have a citizenship derived by birth in a unit of territory, but no unit of territory to which you can go by virtue of that citizenship. Now, I don't accept that that is... I mean, I know Mr. Barbosa has different citizenships, but his overseas citizenship will be rendered meaningless in terms of any territorial right of abode. On the construction...
I thought you accepted that he gets the right, by virtue of being a British overseas citizen, to come to the United Kingdom.
No, not by virtue. I mean, I do accept he can come to the United Kingdom, but it's not by virtue of being a British overseas citizen, it's by virtue of being a British citizen. His British overseas citizenship, which he undoubtedly has, and which impacts on his position in Bermuda, is not reflected, on my learned friend's case, in any right of freedom of movement. It's taken out of 11.1, which is the basic provision that reflects the international law norm.
Suggesting that...
I'm afraid I must have missed that. I thought you had told us that the 2002 Act conferred British citizenship on BOT citizens.
It does, Section 3.
Yes.
Section 3. Yeah.
That was why I was asking you.
Yes, but I mean, that doesn't mean he's not a British overseas citizen. He is a British overseas citizen. By virtue of whatever provision we've cited in the case.
Yes. But that citizenship, as a matter of law, results in his being a British citizen and therefore having a right of abode in the UK. In the
UK, exactly. I mean, that I don't dispute. He doesn't want to live in the UK. He wants to live in the territory of which he is a citizen, and that's or one of the territories.
All right. But
you
say of which he is a citizen.
Well, that depends on how you go down the line and look at the territory by virtue of which he possesses British overseas citizenship.
Because there isn't a status of citizenship of Bermuda.
No, I understand.
Bermuda,
that's the whole problem.
Two concepts, status, and then in certain very limited respects in the Constitution, belonging.
Yes. But your Lordship says very limited respects. The fundamental right, which is the right that mirrors the discussion in Chagos, is the 11.1 right. And so that what your Lordship is putting to me is that the court should accept a position in which someone is a British overseas citizenship by virtue of being born in Bermuda, but has no concurrent right to be in Bermuda, indeed is subject to immigration control. See the Crown's reliance on leave to enter, definite leave to enter, which I would say is a constitutional nonsense. That's the way the Crown puts it. So, if we, I mean, looking at things, sorry. There's a gloss on his right to enter the UK.
So, Lord Sales, you made the point that somebody could be born in the UK and live in the UK for their whole life and not be able to be a British citizen. But that's not quite the case, because if somebody is born in the UK and lives here for the first 10 years of their life, then once they've reached the age of 10, they can always apply for citizenship that way via the British Nationality Act.
But through a process of naturalisation.
Through registration as a British citizen. And the same would apply in Bermuda as well, that somebody who's born in Bermuda and lived there until the age of 10 can apply for BOT citizenship, but the question is, does it give them anything more than a passport in Bermuda? Whereas in the UK, somebody who does that becomes a full-blooded citizen and has all the rights to live and work here, etc. So it's not the case that somebody can be born in the UK and live here their whole life and be in Mr. Barbosa's position. It would have to be exceptional, I think.
Well, they could, and we do sometimes come across these cases in the Supreme Court, where somebody's being deported to Jamaica who's actually lived their entire life in Liverpool.
Yes, but perhaps they haven't
Mr.
registered.
Drabble will be very familiar with these cases. But it's usually because they haven't taken the opportunity, or their parents didn't take the opportunity, rather, when the child was 10, to apply for naturalisation.
They can apply from age of 10 onwards, but I guess it's just a question of whether they did or not.
Yeah.
Thank you.
Whatever Mr. Barbosa's relationship with the UK is, there is no dispute that he is a citizen, a British overseas citizen. The question, therefore, is whether it's sustainable in the light of Banco and Pomachewski that there is no territory over which he has any rights. And we say Section 11 should be construed in a way which prevents that anomalous position arising, and can be. So if your Lordships then look over the page from where we were, 544, into 545, top of page 545, we're still in Lord Bingham's judgment. This is not a surprising conclusion, since the relationship between the citizen and the Crown is based on reciprocal duties of allegiance and protection, and the duty of protection cannot ordinarily be discharged by removing and excluding the citizen from his homeland. It's not, I think, suggests that those whose homes in former colonial territories may be treated in a way which would not be permissible in the case of citizens of this country. Hence the disingenuous pretense in the 60s and 70s there was no population which belonged to the outer islands of the Chagos archipelago to which this dispute relates. And then he goes on to consider whether that might be different in emergency provisions. So what Lord Bingham is doing there is definitely talking about the relationship between the citizen and the Crown. That's what he says at letter A. Says that's based on reciprocal duties of allegiance and protection. So that's very similar to the subject-Crown relationship. It's morphed, if I can use that inelegant word, into a citizenship-Crown relationship. And saying it's incompatible with that relationship in the modern world as it was in the old world to prevent the citizen from entering the territory of which he is a citizen. Then the question becomes, how do you apply that to British overseas citizens when there are several dependencies? So that's Lord Bingham. We say straightforwardly in our support. Lord Roger...
And do you say that Mr. Barbosa owes a duty of allegiance to the specifically to some sort of authority in Bermuda?
Well, the Crown in Bermuda.
He owes a duty of allegiance to the Crown in Bermuda.
I mean, done cases too about the different manifestations of the Crown in different parts of the Commonwealth or the dependent territories.
Yes.
But he's a British overseas citizen. He is owed a duty of protection by the Crown as a result of that relationship. Yeah. And no doubt, he may not know it, I don't know, but he would owe a duty of allegiance to the Crown in Bermuda.
Is it, well, okay.
To the Crown. I mean, maybe it doesn't matter whether it's wider than that. What Lord Bingham is saying is incompatible with that relationship. At a minimum, it's incompatible with that relationship to remove Mr. Barbosa from Bermuda. Now,
Well, Lord Bingham seems to assume from the paragraph you've just cited, assume rather than, as it were, explain and spell out, that those who had been born in and spent all their lives living in those outer islands were properly to be regarded as belonging, as belongers.
There's a rather fuller discussion in Lord Mance, which we haven't got to yet, who was also part of the minority. But yes, that is the premise. Rather laboured over paragraphs 42 to 45 of Lord Hoffman, but it's all based on the same premise, that however you describe that, the consequences of having lived for a long time in the outer islands, it produces something which requires express words to remove it. Lord Hoffman says, well, Article 9 of the relevant order couldn't be clearer, and the minority say it couldn't be removed. There was no legislative power to remove it. But no one is saying there isn't an effect of living for a long time in the outer islands. Now, Lord Roger and Lord Carswell, who are the other members of the majority, don't deal in the same way with this issue. They're more concerned with the issue of meeting Sir Sidney's argument that there simply wasn't any legislative power to make the order in council because of the limits described on the exercise of the prerogative to remove people. So, frankly, it's not easy to go to any passages touching on this issue in those other two majority judgments. If your lordships do look at Lord Roger on paragraph 89.
Just before getting there, I note that in paragraph 79 it's explained that Chagos was a colony by cession.
Yes.
So that it leaves in my mind at any rate a question whether the common law really worked in the Chagos archipelago. I mean, you're describing the rights in question here as having been originally common law rights. It doesn't look as if in Bancal they necessarily were, but I have in mind your submission, it may not matter.
Somewhere in Banco, and I don't think I've missed it so far, so it must be in Lord Mance, is a discussion about how the difference between ceded colonies and other colonies doesn't matter in public law. It may matter in private law for property rights, but doesn't matter in public law. That's the thinking.
It is Lord Mance.
It is Lord Mance.
Yeah.
Then I'm going to come to it. Hopefully I highlighted it. Yep. Lord Roger, in paragraph 89, does say, on the basis of these, that's EB 550, on the basis of these various authorities, it appears to me certainly arguable that there is a fundamental principle of English law that no citizen should be exiled or banished from a British colony and sent to a foreign country, assuming that Section 9 of the Constitution Order is inconsistent with that principle by reason of declaring that no one who used to live in the archipelago now has a right of abode in Biot, is a section void as purporting to change the law of Biot in a way which is inconsistent with that fundamental principle. And then the rest of the judgment goes on to deal with the limits, whether the limits that were argued for and the exercise of the power truly existed, and holds that they didn't, which is why you get the majority.
So, Lord Roger, and I wonder in fact whether in paragraph 70 Lord Bingham isn't doing the same, seems to posit the question in terms of we've got a group of people who are citizens and they're being removed by some action of the Crown. Is that lawful? And then the question is, well, if it's done by legislation, it may be. And that's what seems to divide the majority and the minority.
Yeah.
But in the case of Mr. Barbosa specifically, he had no rights pre-existing the Constitution. So
Doesn't matter.
how can it be said that the Constitution is removing his rights and therefore that the Sims principle is engaged?
That comes down to the relationship between 11.1 and 11.2. My case is that 11.1 is the legislature the framers of the Constitution placing into the Constitution the very rights which echo Magna Carta, Bhagwan, and everything else that's relied on by both the minority and the majority as informing this analysis, and then saying it is legitimate to not grant that right to Mr. Barbosa in 11.2. Now, chronologically, that is not at that point a removal,
No.
except that, but it is claiming a power to cut down the 11.1 right in the case of people who fall into Mr. Barbosa's category. In other words, to claim a power to say, you need indefinite leave to remain, or you need leave to remain, or I can curtail your leave. That's the whole structure of 11.1 and 11.2. And that, I say, is just inconsistent with the whole line of thought in Banco.
But I think what I'm putting to you is, since Mr. Barbosa doesn't have any rights sort of before the Constitution came into existence, before he was born, why is the principle in Sims engaged if one construes section 11.5 as an exhaustive definition section? Because then it's simply saying which people do have the rights in 11.1 and which don't, and Mr. Barbosa doesn't. It's not taking them away, it's just saying people in his category don't have those rights.
But it is producing a situation in which the position that would otherwise result from the common law and the international law norm is not produced in the Constitution of Bermuda, because the apparent grant of the right in 11.1 is removed I don't mean chronologically removed, it's not carried forward by 11.2. And so the moment you have an ability to appeal to the situation as it exists outside the Constitution, as you did for the outer islands in the Chagos, outer islanders in the Chagos, and as you do in the other cases which are discussed later in Lord Mance, and Lord Mance twice, because he does the same analysis in Hartigan, then you are, in the form of the Attorney General in this court, claiming a power to refuse to grant to Mr. Barbosa the very right in 11.1, which on the face of it is a position as a result of the grant of citizenship produces. He was a citizen of somewhere when he was born.
Portugal, I think you told us.
Sorry.
You could presumably say that as long as there was somebody in Mr. Barbosa's position immediately prior to the grant of this Constitution, and there's no transitional provisions here, that person's existence and rights, if he's got them, would give rise to the very question of construction of Section 11 with which we're dealing.
Yes.
And if it, in relation to that person, is to be resolved in favour of a broader interpretation that leaves what you might real belonging in place alongside deemed belonging, then what's good for that hypothetical person is also good for Mr. Barbosa.
Yes.
Yeah.
Well, isn't the difficulty with that, which often arises when you're applying the Sims principle, as to which category of person you read up or read down the provision to cover? So you could read down the provision to cover people whose rights were actually removed when the Constitution came in 1968.
My rhetorical question, why on earth would you do that?
But which would still, which would, sorry, just to make the point, which would still not assist Mr. Barbosa.
Yes, but why would you do that? I mean, why would you read it down in those circumstances? You need to produce, I mean, we haven't got to the cases on the construction of constitutions, but one of the abiding themes of them is that you start with the General Declaration of Rights, as we do in the Bermudian Constitution, in Section 1. You can apply generous and purposive construction so as to protect the rights. And that applies whether you're born before or after the application of the Constitution. We say, without Sims, Sims is not the be-all and end-all of this case, but without Sims, there's a sufficiently large body of authority for the proposition that citizenship or its surrogate citizenship acquired because of a relationship with a particular dependent territory carries with it rights of abode, and you should not be subject to a system of immigration.
Yes, I mean, I follow that, but just in answer to the question that you posed, why would you do that? If you are dealing with a Sims case, it might be said you do it because in the one case, rights are being taken away, but not in the other case.
Yeah. Well, I don't face an argument from the other side that you need to be done in that way. I face an argument that Section 11.5, despite the use of the word deemed, is actually a definition section. That's, you go in a very long, don't worry, I've been through this more than once in my own head. You go through a very long circle, then you come back down. Do you have to construe 11.5 so it's a definition section, or do you give effect to the general purpose of the Constitution?
Well, you only have 30 minutes remaining, I'm afraid, Mr. Drabble, so we really must sit patiently and listen to what you have to say.
I'm not going to defend myself. Well, is it 30 minutes? Right, if we can then go to Lord Mance. Page EB 572, 151, says, Mr. Crowe submits, nonetheless, that the Crown's subjects inhabiting Biot had no public law right of abode, that's the, and nothing of which they could therefore be deprived. It's common ground that this would not be the position in the United Kingdom. The right is fundamental, and in the informal sense in which that term is necessarily used in the United Kingdom context, constitutional. And then there's a reference to Magna Carta, which add to Blackstone. Your Lordships can see that. And then if your Lordships then go down the page to just above letter E, in the same paragraph actually, in respect of persons who were British citizens by virtue of their connection with a part of the Commonwealth other than the United Kingdom, that right was from 1962 onwards made subject progressively to statutory qualifications. See Bagwan, and Bagwan's in the bundle, I'm not going to go to it now, but there is a long history of the evolution of immigration control in Lord Diplog's judgment in Bagwan, and ex parte Azam, when the Immigration Act came into force. All Commonwealth citizens in the United Kingdom without leave were liable to prosecution, but the common law right to enter and remain within the United Kingdom remains unchanged in respect of those with British citizenship based on their connection with the United Kingdom. So there we've got into the way of putting it. It's British citizenship based on the connection with the United Kingdom. The common law position relating to aliens differs significantly, and there's some citations which I won't read. If we can jump on to 153, Mr. Crowe submits that the common law principles governing persons with a right of abode in England have no relevance to ceded territories like Biot. In this submission, inhabitants of Biot never had any right of abode, and certainly none which could survive or be the basis of any objection to Section 9 of the Biot Order 2004. In any event, he submits the concept of an inhabitant of Biot is too uncertain to receive legal recognition. As to the later submission, there may be issues about who in and after 1965 was an inhabitant of the Biot, as opposed to an inhabitant of, say, Mauritius, or the Seychelles working as temporary labour in Biot. However, it is clear enough that there were at least hundreds of persons who could properly be described as Cherkessians, even though they had no property rights in Biot as a matter of private law. Above all, it is, as Mr. Sidley submitted, clear that Mr. Banco was a Cherkessian by birth, and there was no difficulty in identifying the concept of a Cherkessian for the purposes of the 2000 Ordinance. And obviously, there's a difference. Mr. Banco was born before the order that removed the rights, but nonetheless, so there is Lord Mance applying the thinking of the very end of paragraph 151, British citizenship based on their connection with the United Kingdom across into the Chagos situation. 154, as to Mr. Crowe's former submission, the common law position must, in my opinion, that every British citizen has a right to enter and remain in the constitutional unit to which his or her citizenship relates. That is the case in the United Kingdom. And then he goes on to deal with the potential distinction between ceded territories and other territories, resolves that at the beginning of 155. However, no such distinction exists as regards public law, or in particular as regards constitutional questions, including the nature and extent of the Crown's prerogative. Even where the Crown acquires overseas dominions by conquest or succession, the relationship between the Crown and its subjects becomes alike subject to public law principles to those applicable in the United Kingdom. Set out. And then he summarises it all at the end of paragraph 155, page just above letter B. As Mr. J.H. Lambert pointed out in a confidential memorandum on the status of its inhabitants of Biot, disclosed by the government in these proceedings, if such Chargassians applied for a UK passport, presumably the colonial endorsement could only reveal that they belonged to Biot, since there was no other British colony to which they could belong. Mr. Crow's submissions that the Chargassians had no common law right of abode in Biot, close to treating them as if they were aliens, and is one that I would reject. Now, that applies straightforwardly to this position. It's indeed the Crown's position in this case, the Attorney's position in this case, that Mr. Barbosa does require indefinite leave. And that is treating him effectively as an alien in relation to the territory which he claims the right to enter. That is Banco. If I can then go on to...
If we are moving on from Banco, it is perhaps worth pointing out that this is all in the context of rejecting the submission at paragraph 153, which was very specifically the point that my Lord Briggs raised earlier on. It looks as though the government was simply saying, this is ceded territory, therefore no common law rights exist at all. Yeah. And it's that argument which is...
That argument which is being rejected at the paragraph I've just read, I certainly agree with that. I mean, that's why I read it. But...
Well, if there was a submission that the common law didn't give him a right of abode even in a non-ceded territory, he rejects that one as well.
Absolutely, yes.
Yes, in a sense, for sure, right.
I mean, he states the position in relation to the UK at EB 573 letter F, and then goes on to say it doesn't matter, same position in relation to colonies, ceded or unceded, and solves the historical problem by talking about the unit from which your citizenship is derived. And if we then go on to Pomachewski, which is second volume of the Authorities Bundles, tab 15, page 380 of the electronic bundle.
380?
380.
Thanks.
It starts at 380.
Yeah. Yes.
We're actually concerned, if your lordships look at the head note of 381, it describes Mr. Halligan's position, and the actual issue was whether the extradition proceedings, which would require a British subject to go to Poland, engaged his civil rights for the purposes of the ECHR. And the answer to that required the analysis by Lord Mance, which your lordships will find at EB 399, page 31. This examination of Strasbourg case law shows that the Commission and Court have stood firm against any suggestion that extradition as such involves the determination of a criminal charge. jumping. The cases involved are all also cases involving the extradition of aliens. The last two decisions emphasise the proceedings for extradition of aliens do not involve the determination of any civil rights within the meaning of Article 6.1. By the same token, they underline a potential difference in this respect between aliens and citizens. Both in international law and at common law, British citizens enjoy a common law right to come and remain within the jurisdiction, and Mr. Halligan is such a citizen. And then he cites again Blackstone, says this passage was cited and approved by Lord Hoffman in Banco. In the Crown against Bagwan, Lord Diplock spoke of the common law rights of British subjects to enter the United Kingdom when and where they please, and on arrival to go wherever they like within the realm. In Van Duyn, the European Court of Justice recognised it's a principle of international law, which the EEC Treaty cannot be assumed to disregard in the relations between member states, that a state is precluded from refusing its own nationals the right of entry or residence. Principle is the necessary corollary of the state's rights, subject to the obligations undertaken by the Geneva Convention and the ECHR to refuse aliens permission to enter or stay in its territories. Were it otherwise, the Flying Dutchman would be no fleeting phantom. In these circumstances, Mr. Halligan enjoyed a common or civil right, law right, to enter and remain in the United Kingdom as and when he pleased. That's it. But he's describing the right as a common law right, obviously translating that into Article 6 terms into a civil right. I repeat that I don't think it's necessary for my submissions to say that the right is a common law right that exists forever or whatever. It's simply a right of the sort seen by Lord Hoffman, which calls for a particular approach to the construction of Section 11. She's certainly describing it as a common law right. Baroness Hale, paragraph 49, page 403, says, the right of a person to enter and remain in the country of which he is a national is the most fundamental right of citizenship. The United Kingdom has signed but not ratified Protocol number 4, Article 3 of which makes this crystal clear, but as Lord Mance has demonstrated, has been part of the United Kingdom law for centuries. It's perhaps more questionable whether it counts as a civil right, and then it goes on to discussion of that, and of course that's not the subject matter, but she's looking at the right to enter into the territory of which you are a citizen, a right which has existed for centuries. That requires modification in the case of British overseas territories because of the fact there's more than one of those territories, and you have to apply that. That is why you've got belongers. Those are the authorities on the nature of the right. I should have my submissions on that. I now go to the principles of interpretation applicable to constitutions. And it possibly is helpful just to remind the court of the way in which the first instance judge, Mr. Justice Hellman, put this in paragraphs 12 to 19 of his judgment, which is at page 21 and 22 of the electronic bundle. Paragraph 17 draw attention to various passages in the judgment of Lord Wilberforce in Fisher. And I'm going to go to Fisher in a moment, fairly shortly, bearing in mind the time. Lordships will see what the judge says about Lord Wilberforce's use of the word deemed. We'll just look at paragraph 19, EB 22. Sorry, I'm skipping. I'm complicating things by trying to take it too quickly. Lord Wilberforce in Fisher did make comments which your lordships will see at paragraph 12 of the judgment, page EB 20. Thus, fundamental rights and freedoms are stated as the right of every individual, and Section 11 is a provision intended to afford protection to these rights and freedoms, subject to proper limitations. Section 11 states the general rule of freedom of movement, which is to include the right to enter and to reside in any part of Bermuda, but it allows as a possible derogation from this right, restrictions in the case of any person who does not belong to Bermuda. And then Section 11.5 then defines the classes of persons who belong to Bermuda. Among them is the child. And then the judge says, in my submission correctly, in my judgment, the reference to defines is obiter does not form part of the ratio of the case. It is not a necessary link in the chain of reasoning which led the board to its decision. Put another way, whether or not Section 11.5 contains an exhausted list of persons who belong to Bermuda is irrelevant to the question of whether in Section 11.5d child includes an illegitimate child, which was the question in Fisher. If your lordships, just to pick up the passages in Lord Wilberforce's judgment in Fisher, will go to Fisher, which is at tab 13, EB 352. The issue in the case was the meaning of child in the list in 11.5. The passage I've just read from Mr. Justice Hellman is at EB 359 between letters D and F. So the structure of that passage is that he has just cited Section 1 of the Constitution, page EB 358, set out 11.5, and then says, thus fundamental rights and freedoms are stated as the right of every individual, and Section 11 is a provision intended to afford protection to these rights and freedoms subject to proper limitations. Section 11 states the general rule of freedom of movement, which is to include the right to enter and to reside in any part of Bermuda, which it allows as a possible derogation from this right, restrictions in the case of any person who does not belong to Bermuda. Section 11.5 then defines, that's the word which is said by the judge to be obiter correctly, and then there's a thing about child. And then, I'm not going to read this, but there's a passage which I invite the court to bear in mind on the approach to the interpretation specifically of the Bermudian Constitution, which starts at page 328, letter E.
361 electronically.
Oh, sorry. I've jumped unconsciously to the internal page numbers. 361. Letter E. And runs through to internal 330, letter A, 363, letter A. Now, I've said in the printed case that this general approach to the construction of constitutions is now more than familiar. Can I just highlight, first of all, Lord Wilberforce posits two routes to the construction of constitutions. He says just before letter C, on the particular question, this would require the court to accept as a starting, he described, it's just above letter C, two possible answers to this. The first would be to say that recognising the status of the Constitution as, in effect, an Act of Parliament, there is room for interpreting it with less rigidity and greater generosity than other acts, such as those which are concerned with property or succession or citizenship. On the particular question, this would require the court to accept as a starting point the general presumption that child means legitimate child, but to recognise that this presumption will be more easily displaced. The second would be more radical. It would be to treat a constitutional instrument such as this as sui generis, calling for principles of interpretation of its own, suitable to its character as already described, without necessary acceptance of all the presumptions that are relevant to legislation of private law. It's possible that as regards the question now for decision, either method would lead to the same result, but their lordships prefer the second. This is in no way to say there are no rules of law which should apply to the interpretation of a constitution. The Constitution is a legal instrument giving rise, amongst other things, to individual rights capable of enforcement in a court of law. Respect must be paid to the language which has been used and to the traditions and usages which have been given meaning to that language. Quite consistent with this, and with the recognition of rules of interpretation may apply, to take a proposed departure of the process of interpretation a recognition of the character and origin of the instrument, and to be guided by the principle of giving full recognition and effect to those fundamental rights of freedom, with a statement of which the Constitution commences. So you look at the rights guaranteed by Section 1, those include Section 11, and provided that you're applying a genuinely process of interpretation, you adopt a liberal approach to the wording. And at the foot of the page, there's a phrase which directly covers 11.2d. Section 11 starts with a declaration of the right of freedom of movement, including that of residence, entry, and immunity from expulsion. These rights may be limited in the case of persons not belonging to Bermuda. A test not identical with that of citizenship, but a social test. So,
what do you understand that to mean? Social test.
I've read it as a test incorporating attributes similar to those arising from citizenship.
Birth would meet the test. Birth.
Yes. Yes. I agree. I've stared at it and I'm not quite sure. But in my symmetry, it's recognising we're not dealing with citizenship, but we are dealing with a social test of the same character, of the same general kind. That's the way I've read it. Certainly that's consistent with the whole tenor of the judgment. Now, our printed case cites another passage on the interpretation of constitutions, which is from Matthew, one of the line of cases in the Caribbean about the mandatory death penalty. Matthew is at tab 12, volume 1, tab 12. And starts at EB 313. The majority held that the provision that was in question, which was a savings clause relating to existing law in the Constitution, was so clear that you had to apply it, even if you didn't like the answer. The minority repeated sentiments which can be found in large numbers of the cases in the Caribbean relating to this topic. And the passage, I'm not going to read because I see the time, but the long passage is at paragraph 41, EB 337, through to the end of paragraph 44 at EB 338.
And is that passage from the majority or the minority?
It is the minority. I'm sorry, I only went to this because I'm very familiar with it from another case. It's repeated. It's the sentiments are repeated in a whole line of the cases.
Yeah.
The divide between the minority and the majority was that the majority held that the savings provision in Section 6 of the Trinidad and Tobago Constitution, which is what I was concerned with in the other case, was so clear in the case of the mandatory death penalty that you just didn't get into any of this. I'm relying on this as just a source with which I am familiar, setting out the general principles. One of the general principles is, of course, that expressed at paragraph 43, which is the every written law should be construed as always speaking. General principle of statutory interpretation applies with particular force to constitutions. Their effect may change over time and is not frozen at the historical moment of birth. Yeah. Now, against that sort of background, I don't know whether the draftsman thought there was a common law concept of belonging. May well not have done in 1968. We now know there is, and our task is to look at the language of the Constitution and the underlying concepts to see whether, on a genuine approach of interpretation, they can protect my client, and we say they can. Now, I haven't taken your lordships to Sims. I don't think the concepts of that concept is very familiar, or to the case law on deeming. We set it out in the printed case, but it's enough for my purposes to simply say that the word is deem, and the ordinary meaning of deeming is to bring something in. And certainly there is no exclusionary rule stated as a matter of language that one can discern on the face of the statute. And my Lord, those are, I think that's what I'm supposed to be quiet, and those are my submissions.
Well, we are even more grateful to you than usual for answering the very many questions we had for you, Mr. Drabble. Thank you very much indeed. Mr. Sanderson, do you follow?
No, I think there are a couple of points raised by Lord Sales that haven't been fully answered, but perhaps we'll probably
I suggest we
discuss over lunch.
Mr. Sanderson and I discuss them over lunch, and we'll see what we get to.
Thank you. Mr. Guthrie.
Well, my Lord, as I suspect you will have realised, I say that the meaning of Section 11 is absolutely clear and has to be construed in the manner as explained by the Court of Appeal in Bermuda. If that is correct, it's my friend's appeal, because he effectively likes you to say that you can construe Section 11 in a way which we say is contrary to its clear meaning. And we say that the reasons that the Court of Appeal gave are clearly right, and when one's dealing with the construction of the words of the section, really there's not a great deal of elaboration required. Your Lordships, 5 of you have the section in front of you, and plainly will make up your minds as to what it means. We say that it is very significant that Section 11, subsection 5, begins with the words, "for the purposes of this section." And you'll recall that Justice Baker relied on that. We also draw attention to the use of the word if. If one goes to the tab 1 of the...
Sorry, it's my fault. I'm not sure that I have followed what you say the significance of the words for the purposes of this section is.
Well, they clearly govern Section 11. So, in other words, for the purposes of Section 11, belonging is there set out in the categories where it is set out, and we say it is clearly a definition section. And that is in part indicated by the use of the words for the purposes of this section.
But I mean, if it's only indicating certain categories coming in, as opposed to being fully definitional, well, for the purposes of this section would be as apt in that situation as
well, my next submission, as I think you'll realise, is that it plainly is definitional, and the words deeming in this context do not mean bring in. They mean. Deeming, on the question of whether they are apt to bring in categories which would not otherwise be there, it's important to note that the first of those categories, Bermudian status, is obviously the, if you like, the bedrock of those who would be protected by Section 11.1, because those are Bermudians. It would hardly be necessary to enact a special section to bring them in. And I wanted to take you to some of the authorities on the question of the meaning of the word deemed. I don't accept that it is necessarily unusual to find it as a definition section. My Lord Sales has already adverted to Section 1A2 of the Constitution, where it does indeed exhaustive. It's used in...
That's right, is it? I want
yes.
to check that.
I submit that it's correct, yes. And it is exhaustive, intended to be exhaustive in Section 11, subsection 5. I did come across in one of the cases in Your Lordship's bundle under tab 10, perhaps it's not exactly helpful, but relevant qualification to looking at the word deeming in the judgment of Lord Lowry, which is at electronic page 280. He's talking about it in a different context, but he says at page 280, electronic page 280, between letters E and F beginning, the right way for a court to approach deeming provisions has been discussed and reference has naturally been made to the felicitous and wise observations to be found in East End dwellings and Finsbury Borough Council, Inland Revenue Commissioners and Metro Lands, ex-party Walton, in re Levy. Sound as the principles enunciated in those cases undoubtedly are, they can so easily lead a reader in the direction in which he was already facing. But that's really only a prefatory observation. In the circumstances, I think it's accepted, but the Court of Appeal said it's very important to look at the context, but that the judge at first instance in the present case he'd said that, but he hadn't explained what he meant by it. If one looks at the next case I wanted to show you on the meaning of the word deeming, it's Barclays Bank case at Divider 7. And it's a case involving the Finance Act of 1940. You'll find it's electronic bundle page 195 has the relevant provision which the House of Lords was considering. And if you look at the left-hand column of the legislation where it's set out by the law reporter, you'll see under under footnote 2, Finance Act 1940, section 55, towards the foot of that page, for the purposes of this section, a person shall be deemed to have had control of a company at any time if he then had A, the control of powers of voting, etc. I obviously draw attention to the introductory words, for the purposes of this section. And I wanted to show you what Lord Reid in particular and Lord Denning had to say about that. Lord Reid's the passage begins at page 212, electronic page 212, at the foot of that page. The leading provision requires, voters have found out, that the deceased shall have had control of the company. As the word control was the basis of a new scheme of taxation and was a novelty in estate duty legislation, I would have expected to find it defined in the Act, but unless section 55 subsection 3 is intended to be a definition, it stands undefined. One difficulty about accepting this subsection as a definition is that it uses the word deemed, and that is not a word generally used to introduce a definition. But the draftsman clearly thought that it was a definition because section 58.4 contains the words a company of which he had control within the meaning of section 3 of section 55, and I am not persuaded that I must reject this view by reason of the phraseology of the subsection. The word deemed has often given trouble, and I would adopt what Lord Radcliffe said about it in St Aubyn and Attorney General. The word deemed is used a great deal in modern legislation. Sometimes it is used to impose, for the purposes of a statute, an artificial construction of a word or phrase that would not otherwise prevail. Sometimes it is used to put beyond doubt a particular construction that might otherwise be uncertain. Sometimes it is used to give a comprehensive description that includes what is obvious, what is uncertain, and what is, in the ordinary sense, impossible. I think that the last sentence fits this case. Subsection 3 contains three parts, A, which could be appropriately called a definition, and B, and the including part of and B and the including part, which are extensions, and the composite character of the subsection may explain, if it does not excuse, the use of the word deemed. And then, while you have that case open, at page 541 in the judgment of Denning.
You say 541?
226.
Page 226, electronically 541 within the report. Lord Denning says, a third of the way down the page, section 55 is dealing with the position of a person who has died, person in the singular, not in the plural, and it is to my mind both intelligible and incomprehensive when it is applied to a man's own holding of shares without regard at this stage to his joint holdings. It contains a definition, or what I regard as a definition, of the circumstances in which a person will be held to have had control of a company. The definition is given in section 55.3. The word deemed there simply means held. The subsection is to be read as if it said, for the purposes of this section, again I obviously draw attention to those words, a person shall be held to have had control of a company at any time if. You must remember that the draftsman here is seeking to explain not the meaning of a single word, but the meaning of the entire phrase. A person who had the control of the company at any time. A very natural way of explaining such a phrase is to use words to convey what it is to be understood to mean, or considered to mean, or if you like, what it is to be deemed to mean, for the purposes of this section. If you should try to explain the phrase yourself, you will, I suggest, soon find yourself slipping into the words of the draftsman here, or something very like them. Deemed is not used in the technical sense, which a lawyer uses when he deems black to be white. It is used in the sense which an ordinary man uses when he deems a spade to be a spade. This Oxford or Oxford Dictionary says, etc., to conclude, consider, hold. We say that it's no accident that Lord Wilberforce, when he was describing the section in the passage my learned friend has just taken you to, described it as a definition section, because that is indeed plainly what it is. And we say the Court of Appeal were quite right to conclude that that plainly is what it is, and that it cannot reasonably be read as anything else than intended to provide a list of those persons who belong to Bermuda for the purposes of Section 11. And that is really that. And as I say, it's not capable of enormous elaboration, and there's no reason, I'll come to my learned friend's various reasons for saying you should come to a different conclusion in a moment, but you can only, if you like, take those into account if the words themselves are not clear. I've cited in this case, in the Court of Appeal, as I think you'll have seen from the judgment, the case of Matadine, in which Lord Hoffman says that you only get into these, so to speak, special constitutional means of interpretation, etc., where there is some need to do so, where the words of the section are not themselves clear. And that is not contradicted by Fisher. There was no damage done to the section in Fisher at all by construing the word child, including both legitimate and illegitimate children. Child can equally well apply to both, but it is not possible to read into subsection 11.5, where it particularly refers only to a British overseas territory citizen by naturalization, an additional category, which it doesn't have.
I wonder whether, going back to page 212, in what Lord Reid said, where he says that he would expect in context to find the relevant concept defined, whether you might say, given the constitutional importance of being a belonger for certain provisions, section 11 and section 12, that one might expect to find that important concept defined. So,
that's exactly what happens in section 11.5.
Well, I appreciate that it leads into that, and whether you might, if you like, can compare that with what has happened in relation to status, which, if anything, might have been thought to be an even clearer concept, but the draftsman is still to have cared to define it in section 102.3.
Well, I don't see anything to disagree with in what you said.
Thank you.
It's interesting to see that the word is used in 11.5 and also in 103 subsection 2, and also we saw earlier this morning in the British Nationality Act of 1914 as a definition, the way to define British subjects was the following are deemed. It rather looks as though there may be a tradition of legislative drafting that uses this technique.
Well, it certainly appears from the Constitution, we say from the, well, I do rely on the words for the purposes of this section, and then what follows as naturally meaning a definition. And again, as Lord Sales pointed out, section 102 does the same. But I'll come on to this after the adjournment. It seems to me rather wrong to say that section 11.1 confers no rights on anybody because section 11 subsection 2D exists. Fact is that it does confer rights, and they can only be taken away by law. And perhaps I can develop that a little.
Yes, yes. Well, thank you very much, Mr. Guthrie. We'll adjourn now and sit again at 2 o'clock.